Hello, everybody. Welcome to the Public Interest Environmental Law Conference. Thank you for this panel, A New Normal Needs a New Constitutional Amendment. My name is Jack Delarusso, and I am a 1L PILC representative with PILC at the University of Oregon Law School, and I will be moderating this panel. I just have a few announcements before we get started. The first is just a tech warning. Don't worry if you can't see yourself. This is a Zoom webinar, so all the attendees are automatically muted with videos off. So you'll only be able to see the panelists and hear the panelists. Also, throughout the panel, if you have a question, please use the Q&A function rather than the chat function. All of our panelists will be giving their presentations, and then there will be a 15-minute Q&A session at the end where the panelists will answer all of your questions from that Q&A section. Please remember to be courteous of all viewpoints throughout the presentation and through the Q&A session. Additionally, if there are any legal professionals in the audience wanting to earn CLE credit for this panel, we will be dropping the link to register and pay on the JOT form. If you haven't registered, please do so. Also, our alumni board, Friends of Land, Air, Water, help to provide stipends for students doing unpaid public interest environmental law internships. If you're interested in making a donation to help provide these students with those stipends, information to do so will be on a Google document, and we'll drop that link to the chat. Finally, the University of Oregon is located on Kalapuya Alihi, the traditional indigenous homeland of the Kalapuya people. Following treaties between 1851 and 1855, Kalapuya people were dispossessed of their indigenous homeland by the United States government and forcibly removed to the Coast Reservation in Western Oregon. Today, descendants are citizens of the Confederated Tribes of the Grand Ronde Community of Oregon and the Confederated Tribes of the Siletz Indians of Oregon, and continue to make important contributions in their communities at U of O and across the land we now refer to as Oregon. PILC would like to acknowledge the traditional homelands of the Kalapuya people in the Willamette Valley and express our respect to the tribal nations of Oregon. I would now like to turn the panel over to the primary moderator for today, Greg Coleridge.
Well, thank you very much. Welcome to this panel, The New Normal Needs a New Constitutional Amendment. My name is Greg Coleridge. I'm the co-director of Move to Amend, the main sponsor of this panel. Thank you so much to the PIELC for this invitation, to Jack for introducing this panel, and to him and Michelle for tech support, and most of all, to all of you for being here. These unprecedented times of multiple crises, the most existential of which is the threat to a livable world for human beings, and probably at least one half of all other species, demand solutions that are proportionate or equivalent in scale. We at Move to Amend feel part of the scalable solution is a constitutional amendment that would abolish two bizarre constitutional doctrines: corporate constitutional rights and political money defined as free speech, as defined in our We the People Amendment, H.R. 48. The amendment would end the corporate hijacking of constitutional amendments, which has allowed business corporations, including fossil fuel, mining, financial, agricultural, and other corporate entities, to influence legislation and preempt, or dare I say, trump, locally enacted laws by legislatures or by citizen initiatives, all for the purpose of digging, drilling, fracking, injecting, dumping, and spewing to maximize profits by commodifying the earth through plunder. And for the most part, it's all been legal. But are we correct? Is the We the People Amendment the or an answer? What about other amendments? What about fundamental constitutional renewal? How about local alternatives? Extraterritorial jurisdiction? Or is just stronger legislation and regulation the realistic solutions? And how in the world do we build a people's movement for power to achieve what's needed? These are the issues and questions that our panelists will take up here this afternoon, followed by your input through comments in the chat. So just a note, I will be keeping time. Each speaker has 10 minutes, and I have a little bell here that at 9 minutes, I will ring once, and at 10 minutes, more than once. So let's begin. And I'd like to begin by introducing our first panelist, and that is Karen Coulter. Karen is an activist for 41 years, co-founder of the Blue Mountains Biodiversity Project in 1991 and is currently the director. The project uses public NEPA process and litigation to protect national forests in eastern and central Oregon. Her environmental protection activism includes involvement with the Earth First movement going all the way back to 1993, a campaigner and researcher for Greenpeace and Greenpeace International, as well as the Labor and Environmental Alliance, the Alliance for Sustainable Job and the Environment. She was also a principal activist with the Program on Corporations, Law, and Democracy, started in 1996, working on research, writing, speaking, and activist trainings regarding the history of the rise of corporate power, increasing people power, and the affirming the rights of nature. This work includes abolishing corporate personhood. So Karen, just opening question. You spent several decades defending forests from corporate plunder. How have you balanced your efforts of doing the essential work of responding and resisting these never-ending assaults to the land with what you believe is also the essential work of challenging corporate constitutional rights?
She's muted.
And you may be muted. Yep.
Let's
there you
see.
go.
Can you hear me now?
Yep.
Oh, it says
Go ahead.
the opposite. Okay. Engaging in the regulatory process and forest defense litigation should be seen as frontline defense to keep forests standing, as there is a war being waged by the Forest Service against the national forests. Yet this frontline defense lacks a long-term strategy. It is because it's reactionary to what's being done to the forest and because it's constrained by regulatory law. So current laws allow life source extraction to the point of no return for the ecosystem. We need to rebuild the forest movement in sync with the movement for climate change, and we need to shift forest protection from harms-based organizing to rights-based organizing by establishing rights for nature. Through the Program on Corporations, Law, and Democracy, I engaged with research and writing and speaking on the history of the rise of corporate power and lessons for activism. I also work on movement building and broader public outreach that incorporates rights for nature concepts. Property rights are a particular emphasis because they're elevated and prioritized over human rights and rights for nature. Property rights are embedded to take precedence in the US legal system and societal norms. This results in it being legal to poison the water, the land, and the air, to drive wildlife species to extinction, and ultimately to drive the planet to extinction through climate change. Corporations have been given the rights of humans, but not the responsibilities, which is why we need to abolish corporate personhood, because that's how they were given these rights. It is tacitly accepted that a wealthy elite minority can use their wealth as political power to control and oppress the vast majority of people, all the other species on the planet, and ecosystems. Capitalism, by definition, is the accumulation of wealth in competition with others, and also the definition is exploitation of labor, workers, and nature, to the point where nature is always turned into a commodity. This system of elevating private property rights and corporate control results in allowing the wealthy elite and corporations to devise and implement false solutions to climate change. These include carbon trading, which allows polluting industries to continue to emit greenhouse gases, no matter the fate to the planet. It includes carbon offsets that privatize and control indigenous peoples' lands and often turn rainforests that are tropical rainforest carbon sinks into sterile plantations for future logging or for palm oil extraction. Rainforests are also critical to regulate climate for climate stability through ocean thermal convection. Other false solutions include experimenting with ocean and forest chemistry, ocean and atmospheric chemistry through geoengineering at ecological and public health risk with no informed consent by the global public. Increasing greenhouse gas emissions and existing greenhouse gas emissions plus loss of functioning of natural carbon sinks will ultimately result in the end of the planet. Yet politicians will pay attention to anything other than climate change because their campaign contributions are largely, quite often, from coal, oil, and gas corporations and the timber and the mining industries. So elite wealth accumulation and wars need to be substituted with ecological protection and community adaptation where this is still possible. Governments can't be allowed to cave into corporate interests. This is why we need a constitutional amendment to end corporate personhood. We also need to keep corporate and wealthy elite power out of campaign financing. However, campaign finance reform alone is not sufficient. Without abolishing the legal fiction of corporate personhood, we will have an uphill battle to establish rights for nature. We need to reassert that the air, the land, the water, and the wildlife are not private property, but they are part of an ecological commons. We need to change societal norms to respect nature, have reverence for nature, and participate in reciprocity with nature, giving back. The latest Intergovernmental Panel on Climate Change report has been summarized by the United Nations Environment Program as an atlas of suffering, with half the planet's population being at high risk of climate change effects. The IPC is warning that nature is reaching the limit to which it can adapt to climate change now, and that many of the world's ecosystems have already reached the point of no return. Ominously, coastal areas, high mountains, the Amazon rainforest, and coral reefs have all gone from the position of being carbon sinks to carbon sources. The IPCC warns that the window for activism is closing rapidly. There are new roles for environmental lawyers and law students in this work. The rights for nature can be done and has been done so far largely by litigating and establishing precedents, legal precedents for rights for nature embedded in constitutions and international law. The United Nations Global Climate Litigation 2020 Status Report finds that there has been a rapid increase in climate change litigation since 2017. As of July 2020, the number of legal cases pertaining to climate change have nearly doubled, with at least 1,550 climate change cases in the US and another 350 climate change cases across the rest of the world with all the countries combined. Key trends include ongoing and increasing numbers of cases relying on fundamental ecological and human rights being enshrined in international law and national constitutions to compel climate action. Litigants are increasingly bringing claims before international bodies whose declarations can shift and inform judicial understanding. These include cases asserting rights for nature. Rights of nature laws have already been passed in Bolivia, New Zealand, Colombia, Ecuador, and India. You can join these efforts wherever you live to create a new legal platform for enshrining rights for nature instead of property rights, so that we can stop the idolization of wealth accumulation. And we need to change defining laws to effectively reduce climate change and provide for a more equitable future of human rights, environmental justice, and rights for nature.
Thank you, Karen. Under time, in fact, so kudos to you. And just want to encourage people who are attending to please, if you have any comments or queries, to put them in the Q&A. And if they are directed to any one or ones in particular, stipulate that. Otherwise, we'll just open it up to anyone who wishes to respond. So with that, I want to move to our next speaker, Kai Huschke. Since 2008, Kai has been working with community rights groups in the Western United States, including Hawaii, Idaho, Montana, Oregon, and Washington, as an organizer for the Community Environmental Legal Defense Fund, CELDEF. He was a principal member of Envision Spokane in Spokane, Washington, which proposed the very first Community Bill of Rights in 2009, and subsequent worker bills of rights and voter Bill of Rights campaigns. Kai is a lecturer for CELDEF's Democracy School. Kai lives with his family near the confluence of Hangman Creek and the Spokane River, home and traditional fishing grounds of First Peoples for over 11,000 years, including bands of the Spokane, as well as the Coeur d'Alene, Nez Perce, and Palouse tribes. Opening question for you, Kai. Your experiences have led you to believe that what's needed to protect communities in a livable world for humans and other species is bold actions that go well beyond even one or more constitutional amendments expanding or creating real self-governance. What has led you to this conclusion, and what do you feel needs to be focused on and the appropriate strategies organized around?
Yeah, thank you, Greg. And thank you also for bringing this group together. I appreciate being here with John and Ben and Karen to kind of dig into the full scope of possibilities here. I'm going to kind of step into answering the question more directly through kind of two methods. So one is really just reminding us that, beyond what I can bring in through my own experience of doing this work, through the organizing on the ground is also the recognition that we've known what we've been involved in since it even began. So whether it's been the oral traditions of the indigenous people, whether you read about or hear stories of slave revolts, during the height of mass slavery on this continent, the underpinnings of what we're experiencing and what Karen laid out has been there. If you dig into written texts, it's there as well. Whether it's about the anti-federalists who are already warning, for instance, the constitutional construction was going to operate in a manner to do the very things that Karen described. Or during the height of abolition, people like William Lloyd Garrison or Frederick Douglass, speaking to really the evil of the Constitution, to the point of even, burning the Constitution in public as a recognition that it should never have come together under the pain and oppression and damage and violence that it's inflicted upon people through, of course, legalizing slavery. Or, of course, modern contemporary books, whether it's Howard Zinn's book on the people's history of the United States, whether it's other publications like the Indigenous Peoples' History of the United States. I mean, We the Corporations by Adam Winkler, whatever it is. I mean, you can go down the rabbit hole looking into this stuff. So it's not as if this stuff snuck up on us. It's been there all along. The question is, how are we going to deal with it? And I guess two other things to kind of set up where I'll go into specifically your question is also echoing what Karen said is property is king. Keeping that in your mind, property is king under our system. And I would go even further to say that colonialism has never stopped. It still exists. It's just called something else. Call it capitalism, call it the corporate state, whatever you want to call it. Colonialism has never ended, at least for what we're experiencing, not just here, on this continent, but of course the influence and the impacts globally speaking. So I would proffer that we need to understand that in order to figure out what we're going to do about that. Specifically, Greg, to the question of what I have seen through the work as a community organizer working with the Community Environmental Legal Defense Fund, has really been kind of a three-part movement. And we're at the beginnings of really trying to figure out that third movement in my mind. The first movement, our reality, was what Karen described, which was really working into the regulatory world. what we dub as the regulatory fallacy, that somehow if you play the rules of the game by the rules that are set, you're going to get a good outcome. The truth is you walk into a system that is largely predetermined to have an outcome. That's why it's called the permitting process. It's about permitting something. And largely on the environmental side of things, it's about permitting the rate and the volume of destruction of the natural world, of which humans are setting some sort of parameters, often on one signal regulatory point, to say that such and such is allowed so long as it doesn't exceed X, Y, and Z. And we as activists, we as people who care about the natural world, have been told that this is where we do our good work. Often not going upstream to realize that the rules themselves have very often, if not in almost every case, been written by the very industry of which it's supposed to regulate. So you begin to see how this fixed system is fixed. And if we continue to participate there, is it really the system's at fault, or are we at fault to continue to participate in something of which we already know where it's going to land? Of course, we see all the indicators as Karen laid out as well as to where we sit ecologically speaking. Never mind you, of course, economically, socially, culturally, where we sit as well. We're very much in the same place as we sit climactically. And if we are looking at the regulatory world to somehow be the solution, I think we are failing ourselves if we continue to laud it in the way that in some cases still continues to be lauded. So we as an organization got to a point where we stopped doing that. We moved to sort of the next phase of dealing with the system, which is to what Karen was getting at in the sense of this rights-based organizing, really asserting that we have inherent rights. We have fundamental rights. We have rights of other nature that need to be recognized, and we need to be proactive in actually going after those kinds of rights, both in the assertion of what we believe we need, but also to counter the expansion of corporate constitutional rights, corporate power, corporate privilege, because if we continue to play the regulatory game, we are basically dead in the water. And the understanding was we need to do things differently. We have to do things differently. Largely, though, that means still engaging the rules of the system in another way. The way that it manifested for our organization was really about local communities drafting laws, initially what would be called anti-corporate laws, eventually into sort of pro-rights laws, which were the Community Bill of Rights, the rights of nature provisions. So it was both about confronting the system as it is and the harms that it's causing, as well as evolving the notion that we have rights as people, as communities that need to be recognized. And the driving agent of that is really our rights to be self-determining, our rights to self-government, our rights really to local control. Whatever, again, you want to phrase it, of course, in indigenous tribal nations, you know, the rights of sovereignty. Those are all the same kinds of things, whether you're looking at non-indigenous communities, indigenous communities, very often in our own history, also the Black community asserting their ability to have self-determining skills. There is clearly something innate as a human species of needing that and wanting that, regardless of what the system is doing to you. And again, don't be fooled when we say we have a democracy. I mean, all the stuff, for instance, going on internationally now, and that we're there to sort of defend democracy. Well, frankly, democracy doesn't exist in this country in the way that it's presented as existing. But if we want that, well, we have to create it, we have to build it, we have to go after it. And that led us doing work for a large number of years and continue to do that work as well around these assertions of rights through local lawmaking. So really the community coming together to actually put in place laws that recognize these rights, eliminated corporate constitutional rights. So the idea that corporations can override that, and also brought in elements to what Karen set up, this idea that nature can no longer be seen as a thing, as property. We have to actually evolve it into being rights bearing. And it's been a pretty amazing evolution to this point of where that has led in the sense of the possibility, the confidence that gets created when that happens, as well as how that has spread outside of this country. A lot of the rights of nature work, not solely, but can be credited to communities in the United States doing this work, which got other areas to do this work as well. Of course, mind you that the idea of rights of nature is not a new one. It's a very indigenous First People sense of of place and people and the relationship to systems. But when it comes to Western law, the Western construct, the colonial mind, again, which we still live under, it's radically different. It's seismically different. It's 180 degrees different. So one is there's amazing possibility there. And ideally that continues to evolve. But if you're the one who has the keys to the castle, you can imagine you're not going to give those keys up easily. And so you're going to counter, you're going to create pressure. You're going to try to eliminate those who are trying to take away something that you feel is yours to possess, which is really the controls, the levers, the buttons of the corporate state. So what we have seen as this work has evolved and as the corporate mindset, the corporate ilk has seen the potential there, the pressure has been tremendous to get rid of not only organizations like our own, but also the communities who dare to actually challenge power, because ultimately this comes down to power. And what we've seen how that's manifest is through lawsuits, through new legislation, for instance, in the rights of nature realm, making it illegal to actually put rights of nature laws forward. So punishing communities who are looking to this new reality, this new system. Again, not so different than we've seen in other movements at other times, where law is used as the main means to punish, to oppress. As much as we can talk about the brutality of our system, which is one arguably is the most brutal that history has ever seen, it's done so under the rationalization of law. It's been justified through law. All the colonizing powers used law to justify their oppressive genocidal actions. And we're no different in the way that things function today. So where that has led us, because of the closing down of the initiative process, for instance, that you mentioned at the beginning, Greg, or the ability to move law because of how close we're getting to these centers of power and really building the idea that others need to join in for that movement mentality, really is about thinking about what else is possible outside the existing way that rules get set. Which really is about extra-jurisdictional thinking. What does that mean? Well, expansion of mutual aid, for instance, the establishment of citizen assemblies, setting up your own voting system, for instance, if your voice can't be heard because you're being blocked from doing initiatives, literally looking at how do you establish new forms of government, mass protests, mass general strikes, direct actions, whatever it's going to take. I think it's multiple fronts, but we have to put more energy into establishing and creating and believing we can have a different system. And the good thing is we've got lots of examples. We can get there, but it means we got to let go of the methods of how we make change within the existing system and what it says is allowable. Because if we do so, we also begin to delegitimize the existing system and we embolden ourselves to actually make the possible actually probable. And so all of this stuff isn't a cut and dry, it's going to overlap, but we do need to put more energy and thinking towards that. And I know I'm probably out of time, and so I'll stop there and maybe we'll get more questions about that later. So thank you.
Thank you, Kai. Hopefully that does pique people's interests and gets individuals to provide some comments and questions. So thank you very much. Next, want to introduce John Fioretta. John has spent most of his 25-year law career as a prosecutor in California, specializing in environmental protection cases. As a volunteer, he helped lead the campaign to establish the Santa Clara Valley Open Space Authority, a public agency that purchases land to permanently protect it, and serve as the chair, he did, of its Citizens Advisory Committee. For 8 years, he was on the board of directors of Greenbelt Alliance, a San Francisco Bay Area land conservation organization. Since retiring, he has volunteered for Citizens Climate Lobby and Move to Amend. Presently, he serves on the Law and Research Committee of Move to Amend. So the question for you, John, is Move to Amend has been dedicated to organizing to pass H.R. 48, as previously mentioned, the We the People Amendment. What are its provisions? How would the amendment further a livable world? And wouldn't simply expanding statutes and regulations to protect the environment be easier and just as effective? John.
Thank you. First of all, thank you to PILC for giving us the opportunity to do this presentation in front of this very important conference on this crucial topic. To start, before I get into Greg's questions, I just want to mention a little bit of background about Move to Amend. Move to Amend was founded in 2009 in anticipation of the Citizens United decision. We are a private, nonprofit, nonpartisan grassroots organization of hundreds of volunteers organized in 46 affiliates and working groups throughout the country. Since we've started, we've collected over 480,000 signatures in support of our proposed amendment, which I'll get into in just a moment. In addition, we've obtained endorsements from over 600 businesses and over 700 local governments, in addition to 7 states. And currently we have 88 co-sponsors for the amendment in Congress. So what is our proposal? It's called the We the People Amendment. It's House Joint Resolution 48 or HJR 48, and I'll refer to it interchangeably by both of those names. And it does 3 things. First, it says that the US Constitution only protects the rights of natural persons and that artificial entities like corporations have no rights and can be given no rights under the Constitution. Secondly, it says that money is not speech protected by the First Amendment, and federal, state, and local law must regulate campaign finance so that no person, because of their money, has substantially more access or influence on an election. And then third, it simply says that nothing in the amendment shall be construed to abridge the freedom of the press. So basically what it does is remove all rights from corporations. It gives the power to regulate campaigns back to Congress, and it makes sure that nothing said in it will cause a problem with freedom of the press. So how would this amendment further a livable world? Well, to answer that question, let's look at what corporations have done with the supposed constitutional rights that the Supreme Court has created for them. And I'm just going to look at a very few of these. The Citizens United decision eliminated virtually all restrictions on corporate and spending by corporations and the wealthy. And the ensuing flood of campaign money made a bad situation worse. Corporate spending can now easily overwhelm small dollar donations and make candidates for public office more beholden to corporations like large polluters. Under the Fourth Amendment, after a corporate challenge, the Supreme Court granted a right of a search warrant that made surprise inspections for regulatory inspections of businesses impossible, and that makes enforcement of environmental and workplace safety regulations more difficult. Under the Fifth Amendment, the court found that a state law forbidding coal mining corporations from undermining homes and roads was a taking without just compensation, despite the fact that the states clearly have the police power to regulate public health and safety. Other examples of where environmental protection has been frustrated by corporate constitutional rights include hazardous waste transportation, which has been allowed in violation of state law, fracking bans that were overturned, and elimination of subsidies for coal companies, which was prohibited. To focus for a moment on climate change, because it's clearly the biggest problem facing us all now, numerous public agencies have sued big oil corporations for damages based on climate change and for falsely covering up their knowledge of the harmful effects of climate change for decades. And these corporations are now raising the First, Fourth, Fifth, and 14th Amendments, as well as the Contract, Commerce, and equal protection clauses in their defense in these lawsuits. So you can see what is being done in the name of our Constitution because of these very poor Supreme Court decisions. Now, you're probably thinking, is a constitutional amendment really necessary? Couldn't the same result be achieved through statutes and regulations? Even though some constitutional scholars disagree about this, the short answer is no. As you all know, the Constitution is the supreme law, and it trumps everything else. The only way to overturn a Supreme Court decision creating corporate constitutional rights is either for the court to reverse itself or for the people to pass an amendment. Given the current composition of the court, it's highly unlikely they're going to reverse business and corporate friendly decisions that they've rendered. That leaves amendment. To get an idea about what could happen if we don't amend, consider the Lochner era, which I'm sure you've all studied in constitutional law, going back to the late 1800s through the 1930s, when a very conservative Supreme Court used the so-called right to contract to strike down numerous social welfare laws it didn't like. The current situation has the same potential. There are already law review articles about this, and there have already been efforts made to use the First Amendment to do just this. Now, will the We the People Amendment be effective? Well, for an amendment to be effective, it must clearly and unequivocally deny corporations all constitutional rights. It must eliminate the money equals speech doctrine, and it must reestablish that Congress has the legislative authority to regulate political campaign finance. The We the People Amendment does all that and more. Are there any other amendments in Congress that address these issues? Yes, but none of them would require the necessary actions. The most comprehensive one is the Democracy for All Amendment, and this is HJR 1 and SJR 25. It's been introduced in both houses of Congress. But it's ineffective because it does not require that corporate constitutional rights be eliminated. It only allows Congress to distinguish between natural persons and corporations. It does not require that Congress and the states regulate campaign money. It allows reasonable limits, quote unquote, on campaign contributions and expenditures, which of course would give the Supreme Court a basis for striking down any limitations they didn't like. And it does not require public disclosure of campaign contributions and expenditures. There are a few other bills that would establish constitutional amendments, but they aren't as comprehensive as this one, and this one is clearly insufficient. So what is the likelihood that of enacting the We the People Amendment? Passing a constitutional amendment is difficult. Without getting into the details of Article 5, it requires 2/3 of the states to propose an amendment or a convention, and then whatever amendment was proposed to be ratified by 3/4 of the states. It's a heavy lift, but it's not impossible. It's been done 27 times before. There is substantial dissatisfaction with corporate power and money in politics. Polls taken right after Citizens United showed overwhelming public disapproval for the decision. And by that, I mean in the vicinity of 76 to 85%. Additional post-Citizens United polling demonstrated that special interest lobbying and election spending were disfavored by supermajorities of Democrats, Republicans, and independents to the tune of 74 to 79%. In addition, the 700 plus local governments that have endorsed the We the People Amendment demonstrate specific and broad-based support. And I want you to just consider a few of these results in red or purple states. In Montana, 75% of the people in an election voted to support the We the People Amendment. In Colorado, a purple state, it would be 74%. In Salt Lake City, Utah, it was 88%. And in Waukesha, Wisconsin, the hometown of Tea Party Governor Scott Walker, it also passed. A recent book that studied constitutional amendments found that they have been passed in 4 waves, with many years of inactivity in between. The last amendment was 30 years ago. We're overdue. In closing, although this is an environmental conference, all public interest lawyers experience the same challenges, frustrations, and opponents as environmental advocates. And that is corporate power and big money in politics that result in undue influence on the government. HJR 48 would level the playing field for all public interest lawyers. It is the reform that makes all other reforms possible. Without it, we will remain politically gridlocked, legally disadvantaged, and vulnerable to a conservative Supreme Court. Passing the We the People Amendment would truly be a new and positive normal. Thank you.
Thanks, John. I appreciate your contributions and all those heretofore. And once more, before we go to our last speaker, an opportunity again, please consider any questions, queries, consternations, whatever the case may be, concerns in the questions and answers. So type those in and we will throw it at the panel here momentarily. But not before our last speaker, Ben Manski, who is Assistant Professor of Sociology and Director of the Next System Studies at George Mason University in Virginia. He studies the participation of ordinary people, pretty refreshing, huh? In the deliberate constitution of their societies. His work takes in social movements, law, politics, climate, and ecology, and the corporation focusing on democracy, democratization, and constitutionalism. And he has published widely on these themes. In the past, Manski practiced public interest law for 8 years and managed national nonprofit organizations, direct action campaigns, and political campaigns and parties for 25 years. He is a co-founder, actually, of Move to Amend. So Ben, in researching as you have fundamental change in other nations, you've found a correlation, if not direct connection, between constitutional changes that benefit people, if not the planet, and the power of people's movements, democracy movements. How effective do you feel are the efforts of Move to Amend and others striving for other forms of constitutional renewal in what's needed to bring about and create systemic change?
Thanks so much for assembling all of us and for the opportunity to have this conversation. I appreciate the opportunity to go last as well to hear the thoughts and remarks, and I really appreciated, John, your discussion just now in particular, because I'm thinking back right now to those days in which we were meeting in the fall of 2009 to organize what became Move to Amend and to get ready for the Citizens United decision. It was a meeting in advance. It was a seizing of an opportunity for networks of activists and people's lawyers who had been working together for many years. I don't remember if you were there, Karen, but I remember we actually met 30 years ago this year when I first moved to Portland, Oregon. So some of these networks were activated to get ready for the Citizens United decision coming down. And I'm thinking back to sort of the way in which the first 6 months of that mobilization manifested. We found ourselves extremely successful in framing the majority decision. We launched on the day of the decision. We had 27,000 signatures on our motion to amend within the first day. We were able to build very quickly. We had people wanting to work with us all over the country. And we were consciously a bottom-up mobilization. And what we found was that we were running into interference, but the interference was from some of those who we had maybe naively thought would be closest to us and therefore most friendly. So pretty much the entire campaign finance reform establishment resisted efforts to respond to Citizens United with a constitutional amendment, and even people with whom some of us had long histories. For example, Senator Russ Feingold of my home state This is a picture of the lower Wisconsin River behind me. It's largely where I grew up in Southwest Wisconsin, South Central and Southwest Wisconsin. Senator Russ Feingold, was quite skeptical of calls for a constitutional amendment as a response to Citizens United. So we had to win what activists sometimes call the battle of the frame. Within about 6 months, Common Cause and other Washington-based non-governmental organizations found that they were being told by their members and their funders that they needed to get on board. How we won that, I think, is significant. It wasn't just the sort of approach of building mass participation in constitutional change from the get-go. It was also the specific strategy. When John was talking about those 700 local government and state resolutions, I'm really glad you brought forward the fact that many of them were passed through direct legislation. And in fact, that has been the core of Move to Amend strategy from the get-go. The very first of those resolutions was put on the ballot in my hometown of Madison, Wisconsin, with 22,000 signatures to put it on the ballot. And it passed, as you would expect, with it, I think, about 80% support. And that was done in the midst of one of the largest uprisings of US history, the Wisconsin Uprising, which actually took place earlier in the year 2011. Than Occupy. So it was a significant part of what was happening. So even as people were occupying the state capitol and there were strikes, speaking of general strikes, there were industrial strikes in 3 different sectors of Wisconsin going on. We also put it on the ballot and eventually put it on the ballot of scores of municipalities, including rural, very conservative communities, which all passed this effort. This resolution calling for what became the We the People Amendment. So this was a strategy that relied on popular participation in constitution making. I found myself, for reasons that had more to do with my own trajectory in life, deciding that I wanted to go back to school to get a PhD. I had a JD from Wisconsin. I practiced law, as you heard, but I decided I wanted to become a professor, which I'm happy to say I now am. But the question that motivated my research was very much the same question that we struggled with in the first 6 months, the kinds of internal and external challenges that we faced as we were putting forward this seemingly radical idea at the time, no longer radical at all, that a constitutional amendment was a good idea, that this was a good strategy for moving forward. And some of the kinds of criticisms we ran into were those, for example, voiced by friends like Russ Feingold, who said that we risked opening a Pandora's box, and that if we offered one constitutional amendment, then others might follow. He actually, I should say, he corrected himself within a year on that, and then changed his mind and became an active supporter. There were also concerns about whether we should promote one amendment, which became the We the People Amendment, or multiple. And a number of my co-panelists have already spoken to this, but initially the motion to amend not only called for the text of what became the We the People Amendment, but also for moving forward with the Right to Vote Amendment, which had been championed by Representative Jesse Jackson Jr. of Chicago, and also a Community Democracy Amendment to enshrine the home rule powers of localities in the federal Constitution. We had that argument as well. So my job as a scholar of social movements was to ask the question, even though I had answers to it already, and to look to other cases. And I'll just tell you what I found. I won't describe the methodologies or the cases in great depth. I'm happy to talk with you about them in the future. And I'm under contract to produce a book based on the dissertation. So hopefully you'll be able to read The Constitutional Revolution in a year or so from Rutledge. I put together an analysis of the rate of constitutional change in 243 countries, which is basically to say every country, between the years 1946 and 2012, to look at later democratization, basically to see whether there was any kind of significant correlation between the rate of amendment of new constitutions, of suspensions of constitutions, basically looking at 6 categories of constitutional change and later changes in measures of democratic vitality. And lo and behold, across the core, the semi-periphery, and the periphery, a higher rate of amendment is strongly correlated with a later democratization, 5 years, 10 years, 15 years down the road. On new constitution, it was mixed, right? And so I went into a second stage of my study, which involved a comparative analysis, what we call a configurational analysis or qualitative comparative analysis, looking at the 11 countries that were top 30 GDP countries at the end of the 20th century that went through a formal process of constitutionalization. So these were countries ranging from Poland and Russia to South Africa, Brazil, Spain, Canada, Australia, Saudi Arabia, etc. And basically what I found with that study was that democracy movements that encountered a rupture in which there was an opening, in which the constitutional framework was called into question, right? In which there was a formal process, oftentimes instigated by these same movements, but not always. Sometimes there was a meeting of movements from above and movements from below. But when they encountered that opening, if they had engaged in a politics of revolutionary constitutionalism, which is to say, a politics in which they built a participatory process for articulating a constitutional vision for the new society. If they had done that, in other words, if they had prepared themselves and their people to define the new society, they did much better. And if they didn't do that, they lost in every single case. Okay, so just to give you an example of some of the sort of the best cases, South Africa is probably the most famous. There was the Freedom Charter of the 1950s that served as, which was a participatory bottom-up process, mass assemblies that really served to cohere and act as what social movement scholars call a master frame for the freedom struggle in South Africa, and prefigured the participatory constitutional process of the early 1990s. Okay, also Canada, just to our north, oftentimes treated by political scientists as so-so, but I think on further reflection has a lot to offer. In the 1980s and early 1990s, went through 3 stages of popular participation at a mass level in constitution making. And that was really sort of a meeting between an effort that had started with the Cooperative Commonwealth Federation, which became the New Democratic Party with the Regina Manifesto in the 1930s, and then an opening from above, a movement from above, when people in power, in other words, Papa Trudeau, decided, hey, we've got so much instability, we have to have a new compact. Okay, so am I just about out of time?
1 minute.
1 minute. Okay, so I'll wrap with this. The outcomes were pretty clear. Not only were democracy movements more likely to get what they wanted into the writ text that was produced out of the constitutional process when they operated as systemic movements, in other words, on a mass scale, and had a politics of revolutionary constitutionalism, not reform, which is to say amendments, not institutional, which is to say fighting over interpretation of the courts, not expressive, which is to say, here's our opinion, that's all people could do in China, for example. But when they, not only did they get what they wanted in text, but substantively, in terms of substantive outcomes, they were much more successful when they practiced those politics. So the short answer is, yes, absolutely, move to amend strategy is central to winning any kind of new society in which democracy is a reality for the majority of the people. I'll stop there.
Thank you, Ben. Thank you to all of the panelists. And I'm looking, a few comments and questions have come in. Have already been responded to by Kai. If what any of the panelists have presented have sparked your interest and questions, please share those. I will ask one just to start things off, and feel free to sort of engage with one another. But Kai sort of mentioned the 3 sort of stages of engagement or activity and action, sort of a progression between sort of working within the system of regulation and law at the statutory level, moving then to what CELDF and Move to Amend has done, of trying still within the system to bring about some fundamental change, to finally being involved in these extra territorial jurisdictional efforts of doing, if you will, an end run around the existing system, parallel government, alternative structures, local self-determination, civil disobedience, and the like. And yet, acknowledging, well, CELDF is doing a little bit of both. We still do. trying to change things from within, acknowledging that there is still the system being rigged and fixed and the like. And obviously Move to Amend feels it's the same way. So the question is that sort of dual strategy an effective one? Understanding the limitations of it, understanding that the rules are fixed, if for no other reason than for newcomers who may still feel that the system, if you will, is legitimate. And if you just go through the existing kind of laws that we learn in Civics 101, we'll get what we want. And by doing so, it demonstrates that it doesn't work, but still the engagement, the involvement does get people aware, to show, to demonstrate, to see that the rules are stacked against us, but nevertheless, you're building movement, you're building organization, you're building leadership, and maybe at the same time needing to do this sort of third way. So can these two different approaches coexist with one another? Open it up.
I'll take a stab just quickly. I think Ben kind of laid it out in the sense of, if the mindset's about the system is still worthy, if you believe it's still worthy, it's got potential, it's just got to be tweaked kind of a thing, which is what we would call sort of the reformist mindset, which is largely where most political activism still goes. Then you're not going to have a more radical sense that the system itself is the problem, and you're going to want something new. You're going to want to transform it or revolutionize it. So I think that's sort of the fork in the road moment, kind of your question. If you walk that transformational fork in the road, I've always been in the mind that there are multiple sort of fronts necessary. So long as you recognize there's an interrelatability between the things and that you're not blocking it. Ben mentioning that, hey, we thought you would be all for this, and suddenly you're blocking it, because you have something invested or you're getting some benefit from the existing system, and God forbid that it changes. But if we see that, as a perfect example, we still often run up against people who practice traditional conventional environmental law, for instance, in that regulatory sense. And there's a lot of people who are just, they'll guard it with their lives. And it's not to undermine their passion and sense of the environment and wanting to protect it. But I always said, well, fine, if those of the tools you have, use them, but you have to create openings, or you don't even have to do the work, but don't block the capability of something like rights of nature to emerge, for instance. So there are ways, I think, to do this where these things kind of overlap. But for those who are going to be more radical in doing the transformational work, we should be supporting that, not belittling that, not shutting that down, because we need a lot of experimentation. We need people being on the front lines in different ways, all the while that others may be looking to do things within a certain, sort of allowable, acceptable way simultaneously. So I think if we can see that, but I think the only way you do that, again, is if you believe the system needs, deeper transformational change, revolutionary kind of change, then I think you can do that. If you're still a reformist kind of mentality, that's like oil and water, I think. I don't think you're going to get there.
Other comments, reflections?
I'll go quick, but I'm hoping that others will jump in here too. I think we're past the point of showing that the system doesn't work. And when I say that not only as somebody who's been involved in movement since I was a kid and done all kinds of things in all different parts of the movement, right? The movement of movements, but also just looking at survey data. Among people who are younger than I am, socialism is more popular than capitalism. What kind of socialism is a good next system question. What kind of system do we want? What are we going to design? How are we going to get there? But the sense of dysfunction is very widespread, and it's now spread even to elites who recognize that the system is teetering. So I don't think it's a question of going through the steps that we know will fail just to show people that the system doesn't work. I do think, however, that we are always operating within the system. When I was active, I mentioned meeting Karen, I was active in the Earth First movement throughout the 1990s, and we brought the rendezvous to Wisconsin, and I'm still an Earth Firster in all regards except for where I spend my time, basically. But we would debate things like, do we drive? How do we use technology? There's no way to escape it, right? So it just becomes a question of developing a strategy that frankly has an ecological sensibility, that recognizes that there are different kinds of roles to be played in a healthy movement, and finding ways to get people to recognize that their different approaches can actually be mutually reinforcing as opposed to contradictory. I also have I've been a Green since 1990, and I was in leadership of the Green Party, ran presidential campaign, did other things. I'm glad there are progressive Democrats. I have lots of friends who are progressive Democrats. I have lots of friends who are communists. I have many friends in the anarchist sector. I have lots of friends who are lawyers, just to throw that in there. So I guess, the point is, do we find ways to work together that reinforce each other's efforts towards common cause, or do we actually allow our differences to be used against us?
Greg, could I take a stab at a couple of the unanswered questions?
I was going to present those.
Okay.
Why don't we deal with them one at a time? First, just so that everyone knows, including people who may not be able to see them, would we, the people, hinder rights of nature by elevating rights of nature, rights of natural persons only?
I think the answer to that is no, but it's going to take another amendment. So that's the short answer. But I have to say, I recognize the issue. I have not researched it yet. And I'd be really curious what the other panelists thought about it.
Go ahead.
Let's see.
Go ahead, anyone?
Well, I think we do need a series of amendments. I actually believe that we need a popular constitutional process, and we need public interest lawyers to be part of sort of building the capacity of the people to engage in popular law again. We talked about, Kai referenced the abolitionist movement. The abolitionist movement was built on a theory of constitutionalism that was sometimes called the Liberty Constitution School or the Case School, but involved mass participation in constitutional interpretation and, as you pointed out, rejection of the Constitution of 1787. So we need that. And so we also need a constitution that recognizes the rights of nature and that also recognizes the rights of future generations. Winona LaDuke, the White Earth community and former Green Party vice presidential nominee and executive director of Greenpeace, among other things, was for a time talking about the need for a 7th generation amendment, an amendment that would require that Congress and by extension all other governmental authorities in the United States in every deliberation take into account the interests of the 7th generation. We need that too.
Karen?
Anyone else want to take a stab at this one?
Can you hear me?
Yep.
Yeah. So yeah, looking at this sort of schism between visionary and blatantly reformist approaches, it's complex because, for instance, I was engaged with civil disobedience with Earth First long before I became part of Blue Mountain's Biodiversity Project. We made a conscious decision to go the legal route because of where we decided to defend, which is Eastern Oregon, where there was no public support for direct action, where when we did try a direct action during the logging without laws period, the salvage logging, we were overrun by regional law enforcement by the end of the day, like 5 times as many law enforcement as there were of us. So it didn't really make sense, and just direct action didn't make sense out here in general. It was not strategic blockading territory, is flat and wide open and so forth. So I ironically went from a critique of the system, a radical critique of the system, and doing direct action to doing legal forest defense. But a lot of other Earth Firsters did too. And it's interesting to me because our organizations that do legal forest defense are much more willing to take risks than a lot of the mainstream organizations that may not have this critique of the system. And then the other aspect to this in terms of forests are that when you're following the legal system, there's flaws in that, obviously, right? And however, when you're doing direct action, that can be a holding action to allow us to keep the forest standing until we can get a legal injunction. So ideally, these different realms will interact to be more effective. Like ideally, direct action people will interface with legal defense people and help them keep the forest on the ground until we get an injunction or until we win. Things like that. And then in terms of litigation in general, you can do more than one thing. You can play that kind of role, but you can also start exploring more visionary litigation and start pursuing that. It's not like we have to be stuck in a box where we don't do anything else. I've tried to avoid that. I've tried to continue movement building and other kinds of activism.
Mhm. I'll just say in response to this question, move to amend, when was it here now, on Human Rights Day in 2020, sponsored a what we call People's Movement Assembly and launched a project called Toward a People's Constitution that seeks to bring together individuals across the political, gender, racial, organizational spectrum, very inclusive gathering of individuals who feel that we need to look at constitutional renewal, if not rewrite, from that perspective. And that work and project does continue. The next question here, let me just throw this out. Does anyone know if there is a significant congressional willingness toward considering or passing the We the People Amendment or a similar rights of nature amendment? John?
Yeah, I'll take a crack at this. I mentioned that there were 88 co-sponsors of the We the People Amendment. The other amendment that I alluded to that is insufficient has 90 co-sponsors. There is overlap between the two, and I haven't done the math to figure out, how many total congressional representatives have voted for both of them. But when you put that together, I think it says there is a substantial amount of support in Congress for some kind of amendment to do something in at least one of these two areas. And that may not be enough for move to amend, but I think it's significant because it is unusual to have that many co-sponsors on a piece of legislation. So that's one response. The other one is this, and this is more based on my own personal experience. When I was doing the open space preservation work, one time we were discussing in a board of directors meeting, what is it that really saves land? What is it that really preserves it for perpetuity? And analogizing to the We the People Amendment, is it really the amendment that is going to make the change? And the amendment is as good as we can do now. And it's the most permanent form of protection that we could possibly get. But a future vote of the people could rescind it. We've only rescinded one amendment, and that was prohibition, but it's been done. And when we were discussing this in terms of how do you really protect property land in perpetuity, what we concluded was there is no legal mechanism that can do it forever because people can change their minds. You have to make it part of their personal ethic. It has got to be so beyond the pale that no one would even think of going to do what they did to Yosemite back in the 1910s when they flooded Hetch Hetchy. Now, I think it would be pretty much inconceivable, although with some of the current members of Congress, maybe I'm wrong. But when they tried to do that with the Grand Canyon, it didn't work. So I think it comes down to, can we, through a people's movement and through a campaign for an amendment, make this part of the vast majority of Americans' personal ethics so that they won't even consider it. And related to that is what I keep coming up against over and over, not just in my work with Move to Amend, but with my work on climate change, is this feeling among people that they've pretty much given up on democracy. You know, it works at some minimal level. You know, we can still say what we want and do pretty much what we want, but the idea of doing a constitutional amendment, it's like they can't even fathom it. They just say, until you get big money and corporate power out of politics, nothing will get done. Okay, pal, so how do we do that? You know, we're trying to do that, and you're telling me it can't be done. So there's a disconnect here. Either that, or people just don't want to spend the time because they think it's wasted time. So we really have to deal with this this idea that we can't change the system. You know, it's got to happen one way or the other, or we're headed in a really bad direction.
Indeed. Other responses? There's another question here before going on, just to sort of share. People interested in finding out more about this People's Constitution project, you can go to peoplesconstitution.us. It's peoplesconstitution.us. Anyone else want to respond to that?
And you're referencing that's what came out of the People's Movement Assembly you're referring to?
Yes,
Yeah.
correct.
Okay, excellent. Yeah. Yeah, I mean, I just want to point out that when we introduced the We the People Amendment at the National Press Club, we had two sponsors. And that was Representative Nolan of Duluth and Mark Pocan of Madison. And so in terms of the question about congressional willingness, it seems like we have much more willingness than we did back then. And Jamie Raskin I met when he was a law professor in at American, right? I don't know, almost 20 years ago. Talking about voting rights and responding to Florida 2000. So a lot of the people who are allies and who have, in his case, written an excellent book, which I have given many copies out and I recommend it, Overruling Democracy. Get your copy. He are in positions of much more power, right? So we are advancing. If you just look at it empirically, we're advancing by any measure. And we also have been living in one of the periods, actually the period of the greatest mobilization in the history of this country. We've had the largest mobilizations over and over again over the last 10 years. And because of the climate crisis, above all, and this is in some ways response to the question about whether change is going to come from within or whether it's going to be forced upon us, the answer is both. The change is coming. Our job as organizers, as scholars, as lawyers, as future lawyers, is to get ready to provide as much aid to the common cause as we can.
A couple of questions let's put together. Ben sort of commented on the first one. Change is a given. The question that remains is, will it be voluntary or involuntary? And the other sort of related is, seems like we are running out of time on a planetary level. Yeah, more than seems like. What can we do quickest?
I think that's where we were getting into, I think what Karen was proffering, that, we we need a lot, and we need it now. if we're going to have any chance. So I think that's where so long as there is allegiance to some semblance of the system being better or just, you continue to legitimize that system. And so long as there's legitimacy, it continues to live. And I think that's a mistake. We have to basically let go of it because it's largely built by myth. And as long as we support the myth, it's going to maintain itself and it's going to maintain its hold. So I think there's a shedding, that has to take place. Otherwise, we're not going to be propelled into the type of action that we truly need. With that said, I feel like there's a lot of sort of energy points out there that are just sort of separated, and there's a harnessing that's needed to make it effective. So on the hopeful side or the promising side, I think we can get there fairly quickly. Because we need to, if we're going to basically fight the good fight. I mean, that's kind of my perspective. My expectation levels are very low. At the same time, I have a lot of faith still in people as people that we can get there. And I think a little bit to what Ben said earlier, sort of the rupture point or the breakthrough moment, or however you want to term it. Historically, those have been very short in the sense of their duration. So there is some big questions that if we can wedge things open enough, what is it that we really want? What is it that we really need? And be very clear about that also to what Ben was laying out in the sense of what he's seen in his research, in the sense of places that have been more successful, as well as, directly resisting, confronting the dominant system as it sits is also necessary in greater and greater numbers. Otherwise, we're not going to get there. And so all of that has to be absorbed, felt, and then ideally driven and organized in an effective way. And we have to get over our sense of guilt or dread or despair. Otherwise, you get paralyzed. And so I think this is where the idea of we got to drop the reformist kind of mentality. We literally don't have time. And you're literally just playing into the hands of the existing system as it's constructed. If we can do that, I think things will accelerate awfully quickly. And like I said, I think there's lots of good things to bring together if they're done with intention. So there's I guess one last thing that said a little bit to what John was getting at, the work we've been doing is often categorized as legal work because there's so much legal discussion that's had and making laws and debating things and research things and this and that. But really it's culture work. It's about changing culture because it's ultimately rules are set there to reflect a certain kind of behavior. And right now the behavior is to basically own, destroy, oppress, and, be violent towards others on behalf of the wealthy elite. That's the value, that's the culture, that's the behavior, the rules that have been set. If we want the antithesis of that, it is about creating that new possibility, and law has a means of doing that. I don't think law is the only way. In fact, I know it's not the only way, but that's ultimately, if we want to have some sort of set of laws, that's what it's aiming to do. And I guess lastly, rights in nature in my mind is really a through point. It's not an end point. Because ultimately we have to get to what John just described, is that it would seem batshit crazy to actually do the things that we do to the planet now. And we don't need a law to tell us that. But we're so far askew in the Western thinking, Western constructs of law and so on and so forth, that we're having to come back to that. Because to me, that's the ideal place we land, where in some cases we shouldn't have laws in the way that we have law today. I mean, that would be the ultimate. But I see rights of nature laws as really moving us really into a behavioral way that we're not today. And that's going to be a giant fight, because those who have power, they don't know any other way. They're just playing the playbook as they've designed it. And if you're going to do something that's going to undermine that, well, they're going to strike back. And it's going to get more and more that's going to happen, the more and more that we come together. But that's the necessary points of conflict we have to be prepared for.
Yeah. Am I mute? Can you hear me?
Go ahead, Karen. Yep.
Okay. I want to say to that, that we need mass climate mobilization because politicians are not listening. I mean, look at what's happening now where thousands of people in Russia under a dictatorship. We are not under a dictatorship. I'm an anarchist. We're not under a dictatorship. Keep that straight. Thousands of Russians, knowing that they will be immediately arrested, detained, beaten, possibly tortured, are protesting the war in Ukraine. We need to take advantage of not being under a dictatorship to raise the level of protest to the biggest mobilization ever on climate change, or we lose the planet. The US leads the rest of the world in terms of setting the norm on climate change, and hasn't been cutting emissions. And the Biden plan is completely insufficient. It would only cut maybe 1% of emissions at most. And there's no guarantee that the electric cars would even be run by a sustainable energy. This is crazy. So we have to, and I see rights for nature as a parallel necessity right now, because unless we change the ethics of this country, the ethical norms, the way other countries are trying to do, like Bolivia and India and other countries are doing this, we have to follow suit. We have to change our ethical way of behavior and our entire social system. And politicians don't want to respond to climate change because of the economics involved, but life is more important than economics.
And just to clarify, you were referring to Build Back Better as being the plan that would only reduce emissions by 1% if it even worked, right? Yeah, I just wanted to make, I just since I know that we're running on time, and this does address the question that was put forward, I do want to make a pitch for this thing that is called Next System Studies, which is probably new to most of the people who are here, and draw your attention to the Next System Project, which is co-chaired by Garl Perovitz, who was Gaylord Nelson's chief of staff, among many other things, an aide to Dr. King way back when, and Gus Speth, who should be familiar to many of you as a founder of the NRDC and now a critic of capitalism, who's convinced that capitalism has to go, but very much coming from the inside, from a very different place than maybe where Karen and I were coming from. So look to that, and then we've been working with them to build Next System Studies as an interdisciplinary area of study. So if you're somebody who's interested in some of the things that we've all been talking about and thinking about how you can sort of link up, feel free to reach out to me or to any of us. And I just want to urge you to do that. The thesis that Gar has put out there about the Next System Project is simply a bit like what I said earlier, that we are in a period of what he calls punctuated stagnation. We're in a long drawn out period of decline. We're not in a period of industrial collapse. We're in a period of long decline, which will have periodic crises. And what that means is that we actually may have enough time to engage in a process of reconstruction. And so that's what Next System Studies are about. And part of that process involves lawyers. So I just wanted to make sure to clear some of that up and extend the invitation.
And how specifically can they reach you?
So I put my email, we don't have the chat, which I usually love to use. So I put it in my response to KD's question, which is under the answered section. But if you, there aren't many Manskis around. If you look for me, Ben Manski, you'll find me right away. My email's on there. If you Google Next System Studies, you'll see that we're the first Next System Studies, but we're certainly not going to be the last program at a university. And there's lots of information there.
Great. Before we end, Kai, how can people reach you and Selda to find out more about what you're doing?
CELDF.org is our website. My contact information there, lots of resources. Happy to converse with anyone that was here and really get into the action piece of this, because it's, we can theorize and talk and all of that stuff, but how is it going to drive into real action is a big need.
Karen, what about the Blue Mountain Biodiversity Project?
Yeah, Blue Mountains Biodiversity Project, you can look at what we're doing at Blue Mountains Biodiversity Project, all spelled out, .org. And if you're interested in a little bit of stress release that is also helpful to the planet, you can call me about volunteering in the forest. It's called forest bathing. It's a good release of stress as well as helping to stop the forest destruction. We base our work on the field surveys. And my number for that is 541-385-9167.
Say that again.
541-385-9167 to inquire about volunteering in the summer.
Great. John, what about move to amend?
Just go to movetoamend.org and use the features there, and I will eventually get the message. I just wanted to give a couple quick responses in the 2 minutes remaining. Anonymous said that some people of color on the panel would have been helpful. I agree entirely. I'm sure all the other panelists do. As well, like other organizations, we have trouble getting people of color into, I know, my affiliate here in San Jose, and would love to hear suggestions on how to go about getting greater attendance from people of color. Eric asks, what's the best suite of constitutional amendments we have on the table right now? I think Ben covered this a little bit, but I think voting rights is crucial. Redistricting is crucial, so that to eliminate gerrymandering. I think abolishing the Electoral College is really important, even though there's a potential fix for that through the National Vote program. I have my own personal views. I think there are a lot of other constitutional amendments. For example, making sure the Supreme Court follows the same rules that every other federal judge follows, which right now they don't. Any rate, and Craig's question about will the change be voluntary or involuntary? I think that depends on whether or not we get an amendment passed that curbs corporate power and big money in politics. We get that. I think everything else people are going to, it is going to remove the impediments to the will of the people being expressed. If we don't get that, then we could have an explosive situation.
I'll just say that to sign our motion to amend, John mentioned 480,000. You can go to movetoamend.org/motion, MOTION, movetoamend.org/motion. And you're quite right, Anonymous, about people of color. Half of our board is people of color. That's at the national level. At the local level, we do have issues and are working on that, no question. Last thing, just to say, if you want to reach out, I'll make sure that John gets that information. You can email me at Greg, G-R-E-G, at movetoamend, Greg at movetoamend.org. So feel free. And thank you so much, Jack, and everyone else at Public Interest Environmental Law Conference for hosting us, and to those of you who participated in taking time away from, I guess you could have been out there taking a nature walk right now, right? So really do appreciate you choosing to spend your time with us here. Hopefully you felt that was worth the while. Thank you so much.
Here, everybody. Oh, thank you, Greg. Thank you all the panelists. We just wanted to apologize again to all the panelists and attendees for the confusion with the links. We want everybody to know that if you had trouble finding the panel at the beginning, the entire thing will be uploaded by the end of the day to our YouTube channel. And yeah, thank you all you panelists, all you attendees so much for being here with us. And we look forward to seeing the rest of you either next year or in later panels this year. Take care, everybody.
Okay, bye-bye.